Hi, I'm Greg Adamore, your host for Experts of Southern Nevada. I'm your real estate coach and a broker at Encore Commercial Realty. And today we have a special guest coming in, Robert Noggle, real estate attorney. And he's going to speak on a few subjects, including one that's near and dear to most of our hearts, principal reduction. Who's getting principal reductions? How's that working out? And can you tell people what principal reduction is?
Well, principal reduction means that the bank is going to reduce the outstanding balance on the loan, and the borrower is still going to pay the remaining balance, but it's a great advantage, of course, to have a loan balance reduced, but it's not always reduced to the market value, for example, and there's no way that a borrower can call up the bank and ask to be included for consideration. They have their own ways of determining who is going to receive an offer. Now, the key question is which banks, and the 5 national banks, under a settlement that they reached last year with the Department of Justice, the feds, and state attorney generals, have committed to a certain amount of loss mitigation. So that includes B of A, Wells, Chase, Citi, and Ally. So the question is, what are they doing right now? Because they have a few years to implement the program, and they get to choose their own processes and policies, is that B of A has been quite aggressive, and as I understand it, about 2 or 3 months ago, they were halfway through their program. Sometimes it's a release of a second mortgage. Sometimes it's a write-down of principal on the first mortgage. But there's just no, it's a lucky ticket. It's like a drawing.
Called it a golden ticket?
Yes. Open the mail is my advice, and respond to phone calls. I've had clients who the banks have asked, why didn't they take the principal reduction offer? It's like, they didn't think it was serious. It's easy to disregard mail, and it's like, oh, it's just more mail from my bank, and throw it away. But open it and read it, because that's how they ask if you want one or to be considered for one. But some folks are just never going to get one. And one category, anyone who has a mortgage that is backed by Fannie Mae, which is, well, everyone thought it was government guaranteed, turned out not to be the case. But Fannie Mae, and you can look, there is a website where you can put in your loan number and the last 4 of your social and find out if you have a Fannie Mae loan or Freddie Mac. No reduction. They absolutely will not do it. That's been the policy for years. There is a nominee to replace the current incumbent. Perhaps he'll reconsider because he has a lot of experience with lending. So we'll see, but that would include FHA and VA.
Oh, I see.
So it's a mixed bag. No one should sit home and plan their entire future based on a principal reduction.
Right. And you said something earlier before the cameras were rolling about, was it Ed DeMarco? Was he overseeing the...
Right. Fannie and Freddie. I mean, his job is to get a return for shareholders as well as to repay the tax dollars that have helped them through this crisis, and they seem to be doing quite well right now.
Okay, so hopefully his success should be a little bit more compassionate, a little bit more sensitive to homeowners' plight.
The administration, the politicians would love to see that. We'll monitor the situation.
And you said these are 5 of the bigger banks, and I think Ally, that was GMAC's before. So they have one of those big banks that should read the mail, because it could come. Could it come anytime during the notice of default or during the foreclosure process or before that? Is there any
I've had clients with city mortgages as seconds, and towards the end of last year, they all got letters saying thanks.
Yeah, a couple of my clients.
Good luck.
They got done. It's zero. Well, see, that way they probably couldn't collect on those anyway. Second mortgages or junior liens. In most cases, they're not going to get any return on those anyway, except maybe a few $1,000s if there's a short sale. So, yeah, that's very good information. If on the normal principal reduction programs, do people generally have to be homeowner, like owner occupied, and current on their mortgages, or is that for the HARP and refinance programs only?
The HARP requires that you be current. The seconds that have been released were not current by any stretch, and the folks who I've seen have had offers. Some have been current and some have not. So
if someone gets some mail and they want you to review the paperwork, you have an email address you can share with us. They can put it on the screen for us, and they can contact you by phone or email?
Sure. My email address is robert@ Noggle, Noggle, law, all one word, no spaces, .com, robert@nogglelaw.com, or call our office at 450-6300, 450-6300.
Yeah, that's great. You consult an attorney that's familiar with the laws and the trends that are happening, because it seems like the landscape is changing every few months. There are new programs, and
absolutely.
And we need to be informed so we can know what our rights are and what our options are. There's some stuff going on in the legislature right now. I guess not that many bills are really being looked at. What is there, a dozen bills, and most of them don't directly relate to real estate relief?
Well, we're not going to know the total result of the legislature's efforts for a few more weeks. Right now we have bills pending. One is amending AB 284, which caused a lot of the lenders to hold back from foreclosures. We'll see if that's amended. There's a homeowners bill of rights, like in California. See if that gets amendments. Another bill that allows someone who's an owner who's been foreclosed to buy it back at basically the market price. So until they adjourn, it's all in suspense right now, and I don't make any predictions about what the final outcome will be. But some of them will significantly change the way the market is, based on whether they're passed and in what form.
So it's a very good idea for our viewers to stay in touch with us at the program, or at Encore Realty or Robert Noggle's law firm, so you can find out what these new changes are, because being informed gives us a great advantage to know how to deal with the banks and know what options we have. Do you foresee judicial foreclosures increasing in today's market? Or?
Well, there have been judicial foreclosures over the last year, and a lender has always had the option to choose between judicial foreclosure and non-judicial, which is what most people have experienced, which is notice of default, notice of sale, trustee sale, all outside of court. Judicial foreclosures are being filed by some banks and by some servicers on behalf of banks, and the whole point of it is to bypass some of the what they consider obstacles that have been introduced into the non-judicial foreclosure process, such as mediation, such as AB 284 and its affidavit requirement, which it does have a criminal penalty for robo-signing. So judicial foreclosure, it's bubbling away. It does occur. And if someone gets a summons and complaint, they should call me right away, because it's a legal process. They seek, the lender seeks to have a sheriff sale of the property, not a trustee sale, and with that, a deficiency judgment. So it is concerning, and it's not to be treated lightly, that's for sure.
Sure. And as an attorney, suppose you're representing a homeowner in a situation like that, and we all know that banks have, staffs of attorneys. It's kind of like David and Goliath. I mean, if somebody were to prevail and you were able to defend them against a judicial foreclosure, are attorney fees negotiable, or would the bank be responsible for the consumer who hired you, or does that depend on the courts?
There's the loan agreement has an attorney's fee provision, which generally those are reciprocal. But for the most part, when I speak with an attorney representing the bank who has filed one of these judicial foreclosure complaints, normally we're working on a solution, so it's not as if they're just going to disregard pursuing the case, but at the same time we're sort of dual tracking it. Over here we're doing some discovery, and over here we're doing a short sale. So when the short sale closes, then the case can be dismissed.
I see. And one of the key words you mentioned was dual tracking, and I think one of the Bill of Rights, or one of the new things being discussed, is that if your property is in foreclosure and you're attempting to do either a loan modification or a principal reduction, or even just a short sale, that they won't continue to aggressively pursue the foreclosure, because what was happening before is like we turned two egg timers over. One's the short sale department, one's a foreclosure, and you think you're just about done with the short sale, and all of a sudden the legal team from the foreclosure department came in and
Well, more of the emphasis has been on loan modifications, where the lender says, don't pay us in order to be considered for eligibility for modification. And then they'd foreclose while the modification was still in the works. So under that settlement, they're prohibited from doing that, and anyone who has that experience should step forward, even regardless of the circumstances, because that's a problem that was so large, it's supposed to be addressed. And if it's not been addressed, there is a monitor for the settlement, and there are ways to make sure that the banks follow what they've agreed to.
Okay. And we were also talking a little earlier about mediation. And I think this is another buzzword. It's a very important tool legally that we can use for for the homeowner. Say somebody's getting a foreclosure notice and they want to do mediation. Do you represent homeowners that go to mediation against the banks? And
yes, I do. I represent borrowers in a lot of mediations. In order to be eligible, first there has to have been a notice of default that has been filed. Second, the property has to be owner occupied, can't be vacant, can't be a rental, can't be a second home. And then lastly, when the NOD is received in the mail, there is an election form to participate in the program. It's not mandatory. And the borrower has to check the box that says, I want to mediate, and put the $200 in the mail per instructions, and now they are going to eventually get their mediation date, and they will force their lender to the mediation table.
Okay.
And that has a lot of advantages.
So then there's is that type of arbitration where you sit down with the homeowner and the bank sends an attorney and you take a good look at whether or not they have standing or they have the affidavits properly, or that there's no broken title and so on. And
it's a little bit of mix and match. It's not an arbitration, so there's no arbitrator who will make a decision as to what the result's going to be. It's an opportunity for a considered discussion pursuant to rules that the Supreme Court has laid down. So the banks do have to bring their documents, and those have to be certified, notarized as copies of the original. So many people think, well, where's my note? They have to produce a copy of that note, certified and notarized, and show exactly how it went from party A to B to C to wherever it ended up. So that's one of the benefits. Another benefit to the homeowner is that a property cannot go to trustee sale pending the mediation, and half the time the banks can't bring the documents, so at that point there's not going to be a foreclosure anyway. And if the rules aren't followed, and good faith is a requirement for both parties, there's the possibility of taking it for a judge's review at district court.
Oh, I see. When a person gets a notice of default, then we find out that mediation is available. Is there 30 days that they have to respond to?
Yes.
So they don't need to wait on this. This is something that they need to respond to in a timely manner.
Right, because if they wait and the mediation program, if they do elect later, is going to send a card, a yellow card or a letter that says, no, you're untimely. So word is, get that form out. It's like, oh, more mail. I don't want any more mail. Open the mail. There's the form. That's right. And I think it's the best $200 any homeowner can spend, because it's like an option. Oh, sure. It's not going to be refundable, but you can't participate later if you change your mind.
Oh, I see. If you went to a mediation, maybe somebody's already been to a mediation and they had some type of arrangement worked out, then later on the bank subsequently files another notice of default, otherwise known as an NOD. Is then the mediation, is it one time only, or is it?
Nope. Every time there's an NOD, there is the option to elect mediation for the homeowner. And what's interesting is sometimes it's going to happen twice, sometimes 3 times, as many as 4 times. Wow. And for a while I was having mediations with one mediator who would always ask my clients, is this your first mediation? Oh, yeah. Because it's so common to have something go awry in terms of how the rules, or whether the rules are being followed, that the bank has to start over. And that's one of the reasons they like judicial foreclosure, because in the old days, when there were lots of foreclosures, the time involved with mediation was significant.
Oh, I see. So homeowners, this is very good stuff to pay attention to. We want to be aware of the mediation process. We want to look it up, get some information, check with the realtor, check with the attorneys. Knowledge is very valuable to have. If you're in a situation where maybe you're waiting to get a settlement, or maybe going back to work, somebody's struggling, and mediation comes available, sometimes that can buy several months or
actually
years,
more. Yes,
if there are multiple mediations.
Right.
And
and any solution that the homeowner wants is on the table, whether it's a short sale, a loan modification, a deed in lieu of foreclosure, a forbearance. The borrower gets to choose. So my client gets to choose the solution they want, and that's where we start. So anything that the borrower wants is on the table. It's not just for loan modifications, which seems to be a common misconception.
Yeah, a lot of people have been disappointed by banks in the past where they were told to turn in all their information, their income, expenses, the financial template, the hardship, basically evaluate the entire profile of the family that's in trouble. And sometimes that information seems to be being used to evaluate whether or not they could afford the home. And
right.
I imagine that'll increase even more now if this passes, where the homeowner who's foreclosed on has a first option or first right of refusal, if we can call it that term, to buy the home back and at what the bank was going to sell it for. So if somebody owns $600,000 for their home and is $300,000 value now, I'm not sure how they would produce that money, maybe through a private loan, or if they had some savings, or maybe
well,
a
that's
family
another
member.
question.
Yeah,
Yes.
somebody just lost their home, but
right.
you can't deliberately just get a foreclosed with the intention of buying it back, or I'm sure we'll have to read that rule.
Yes, my policy is I'll wait to see what actually comes out in print, as this is the new law.
Okay, that'd be great. And what do you see happening in the market now? I think prices have been increasing so fast. And where do you see Vegas in, say, 5 years?
Well, there are two views as to what's going to happen going forward in terms of foreclosures and distressed properties. Mm-hmm. And one is, well, there's still a tsunami coming because there are so many properties where the borrowers are not paying. And it could be as high as 80,000. Obviously, some are vacant. Mm-hmm. The numbers may have come down, but we're number one in defaulted mortgages. Right. So the banks have to do something about those. Right. So the question is one day do they just start and thus the tsunami? Or as someone who was quoted in the paper said, well, maybe it's just like a forest fire. It's been put out for the most part, but it'll spring up and then we'll have another intense round of blazes. Yeah. I think it's going to be an ongoing problem for quite a while because the numbers dictate that. Okay. The banks can't just sit there. I mean, Nevada, to them, and Las Vegas, yeah, we think it's a big market, but it's a relatively small market for them. But they are obligated as servicers and to the bank's investors, if they own the loan, to resolve them. Right. So I think that's going to be a drawn-out process over time.
Right. I've noticed recently, I think Trulia did a study out of San Francisco that rated Las Vegas the #1 market for investors, and they say that we're still about 24% below market, where the market should be, and so we may have a little bit of a bubble, but right now it seems like prices are increasing 25-30% over the last year over last year, and then they're projecting. Now that's assuming all things stay the same, I think, and that the bank doesn't release this shadow inventory of these tens of 20,000s of homes. But the demand seems so strong right now, and it'd probably be good if they did let some of these foreclosed homes at least trickle in like a slower, steady, controlled release of these properties, because prices are up. And it seems those homes that were underwater aren't so deep underwater anymore. So
yes, the percentage of underwater mortgages is decreasing, and I'd have to look at, for example, CoreLogic to get all those numbers. Yeah. So homeowners and property owners are benefiting from that, but many are not. I mean, it's just a dent in the overall problem for those folks.
Okay, and then when we talk about principal reduction, say someone is fortunate enough to get that golden ticket, as you called it before we started, and they owe 4 and they're going to knock it down to 3. Now the homeowner's got more incentive to stay in his home, and continue to take care of it.
Economists agree the best solution to the mortgage crisis is and always has been principal reduction. Yeah. But genetically, it's not in the bank's makeup to do that, and they're always concerned about moral hazard. Like, if we do this, is everyone else going to, if we do it for someone, for example, who's behind or delinquent, why wouldn't everyone become delinquent? Right. So it's an issue for them, and it's understandable, but it's still a better solution than a lot of the others.
Yeah, I think so, because we see a lot of people here in the marketplace who have been invested in their homes, living in them 10, 20 years, and they'll sell them for 50 cents on a dollar, but they'll sell them to someone who's maybe just an investor who never even seen the home, or another foreign national, somebody buying these properties, and these hedge funds are buying up all these properties and renting them out. So we're losing the homeowners, we're getting more renters.
Yes, and that's destabilizing overall. Not that renters are pejorative, but you can have whole neighborhoods where you don't actually have owner-occupied properties because it just isn't healthy. I mean, it's just not.
Yeah, and like most of the people who've been following the market know that for that very same reason, the ratio of homeowners versus renters and, say, condos and condominiums, townhouses and so on, you can almost always have to pay cash if you buy anything in a subdivision. I think there's 180 approximate subdivisions, and maybe 10 are approved for FHA and VA now. Maybe the newer developments will be approved, but you have to have like 70, anywhere from 65 to 80% owner-occupant ratio for condominiums, or what they call PUDs, planned urban developments, to get financed by government loans. And for the moms and dads and the young folks that are going to school, they want to usually get a home. Most of them are going to get an FHA loan, which is a 3.5% down payment, and they're more liberal on the qualifying. So all those folks are trying to get a home to live in are sometimes being bullied or bumped out of the market by cash investors, which I think one of the statistics recently I read was about 6 out of 10 deals are cash.
It's almost impossible for a first-time home buyer who doesn't have all cash, which is not typical of first-time home buyers, to get into the market. And where are the move-up people going to be if they can't get in on the first tier of ownership? Because as we know, the first-time home buyer gets the starter home, then upgrades. Investors aren't going to upgrade.
Oh yeah, no doubt.
They bought it, and that's they're happy with it until their returns don't meet their requirements.
Oh, absolutely. I'm getting a lot of people who have been buying in the last couple of years. They're doctors and wealthy people. They're buying $60,000, $80,000 homes, and they're renting them out. And for 5 or 6 years, in that period of time, they're going to get the return on their initial investment, making $1,000 a month on a $100,000 home. In 5, 6 years, they've, or 8 years in that case, they have a home that's free and clear, and it's an ATM machine for the rest of their life. So they were not even grabbing with the intent of appreciation. But with appreciation coming up 25, 30% a year now, it's important for those first people to contact an aggressive realtor that's knowledgeable, that can really go out there and try to level that playing field a little bit, give them a chance against the big boys. It's tough out there, you know.
Well, when you're competing against hedge funds, they're very targeted. They have a lot of resources. So that is true. You need experience as a first-time home buyer on your side. It can be done. But only if you have someone in your corner who's an advocate and knows how the world works, like you.
Right, and I've been trying to do that for my clients. I'm getting the moms and dads and retired and the young folks a chance to get into several homes, mainly through my website, thebestlasvegasrealtor.com, and give that one a little plug, because we've got like listings there that people won't find anywhere else, with the intention that they won't have to go up against 20 or 30 bids. Because they've had that happen before, and it's discouraging. But the people looking to buy, it's still a great time to buy, and I recommend that you give our office a call and let us know what you want to get qualified. There are going to be more inventory coming available. For the homeowners that are looking to sell, a lot of times they're behind 5 or 6 payments, and maybe there's no chance for work, but a lot of times we can find people that will bring them current and make them eligible for new programs and so on. Getting back to where we started on the principal reduction, is that taxable in all cases?
Oh yeah, anytime debt is forgiven, it's taxable. So then the question is that going to fall, that forgiveness reduction, is that going to become within the coverage of the scope of the tax relief that is now in place for homeowners who are forgiven mortgage debt that was used to acquire the property? And the answer is yes, it's reportable, but through the end of this year, it's going to be forgiven. So there is no tax. Now, if someone receives a principal reduction in a subsequent year, if this Mortgage Debt Relief Act is not extended beyond the end of the year, then there's always another exception for folks who are considered by the IRS to be insolvent. But that's really a question that the borrower should talk to their accountant about.
Oh, I see. Okay. Yeah, because say in the case that we talked about earlier, if a homeowner were to owe $300 and the bank sent them the golden ticket and they forgave $100,000, now they only owe $2, but they're going to get that 1099-C, and I believe the C stands for cancellation of debt.
Yes.
So now they have $100,000 income to deal with.
And through the and no one knows what's going to happen at the end of the year. It really went down to the wire last year with Congress. It really was 2 minutes before the end of the year when they extended it. So we can't count on that happening again. Yeah. And anyone, the insolvency test requires that a taxpayer owes more than the fair market value of the assets that they have. And then they don't. This has been around in the tax code for a very long time, and it will continue. But it's a question for an accountant.
Oh yeah, sure. It'd be good to contact a CPA, and then for legal questions, they can contact your law office, and real estate general questions, they contact mine. And yeah, because there is pros and cons of all these things, and we have to kind of strategically figure out what's going to make sense for each client, because every situation is slightly different. So looking at their current income and their liabilities, and if they have IRS liens or any judgment, so maybe they can contact you and get information. Also, people that are doing quite well. I understand you also do practice in asset protection and living trust.
Yes, I don't engage in the planning for the Nevada Spendthrift Asset Protection Trust, but you know, it's a planning process where you look at assets, figure out if they're already exempt, how you can pump those up, etc. But one thing I will say is anyone who has a property and just thinks they'll stay with the property until the bank takes it back are going to be surprised when the tax bill shows up. So it's something they need to anticipate and plan for.
Oh yeah, and I definitely would check with the CPA right away.
Yes.
I know in primary homes and the Mortgage Debt Forgiveness Act is a really big thing. People should look that up on the internet or contact us. Because again, I've heard from some reliable sources that at the end of this year they will not be extending it. If that's the case, you want to get your short sale in right now. Contact an attorney. Find out. You know, you need to really be careful with your hardship letter. Basically, and you need to make sure in most cases that you have less than $1,000 spendable income when they look at the income versus the expenses on a family has. And so, you know, there are different things besides financial considerations. There
are different kinds of hardships. So a homeowner should not consider themselves or a property owner ineligible for a short sale because they have income and assets. I mean, there are a variety of hardships that will qualify a borrower for a short sale. So they really need to find out what their situation, the only real situation that does not qualify for a short sale is the property's underwater. That's not a hardship. But there are lots of other hardships we can work with.
Okay. I just wanted to also invite you to contact Robert Noggle's law firm. He's been teaching things for 20, 30 years in the community. I know he doesn't look that young, but or that old, I should say. But throwing out Hershey bars and teaching us over the years, exchanges, taught us a lot of things. And so it's a wealth of information that's available to you, and feel free to contact his office anytime. We'll put the information on the screen. And again, I thank you for attending today and viewing. We're very happy to have you here, and we'll be here every Tuesday at 5 o'clock on Experts of Southern Nevada. Again, I'm Greg Attamore, your host and real estate coach, and I look forward to seeing you next Tuesday at 5 o'clock. Thanks so much for being with us.